I think we already started as far as I'm concerned. Okay, given that there is a big difference in the level of people's knowledge and background, I'm going to start with some of the most basic things. Some of you might get bored, some of you might learn a lot from it. And then later on, it'll become progressively, let's call it, more difficult. So when it comes to hopefully the third and the fourth lecture, by that point it will be largely a lot of the nuances of how to go further in the competition. For anyone who doesn't know, just as a background, Jessup is the biggest international law moot competition and the biggest mooting competition in the world. And a lot of teams spend a lot of time preparing for it, not because it's just prestigious, but also because it helps with your future careers, with whatever it may be. It will teach you how to think and how to work. This might sound very basic, but you will see throughout the entire thing, I will be speaking in a bullet point format of, there are 3 points on this. That's all Jessup having been sucked into me sort of through the bone. That at this point I am unable to speak unless I'm talking about how many points of issue there are on any single issue. And it doesn't have to be law. I don't practice law, but still, it comes in very handy. And also, for those of you who want to do well, it will push you to your limits. We used to joke with my teammate, until I did Jessup, I didn't realize how hard I could actually work and how little sleep I actually needed. For a good team who wants to win, the time commitment is significant. We used to say about 15 to 20 hours a week. And that was for us equivalent to about 50% of the time we would spend on our own lectures. So on average, they used to tell us you need to spend about 40 hours a week studying. And we used to say, well, that's another 20 hours on top of that. Admittedly, I don't think anyone ever did 40 hours of studying for university when I was there, at least. There are going to be 4 lectures. I'm sure you've all looked at the program. You are well aware of it. First one is meant to be about research. Secondly is writing, then about oral advocacy, and then finally slightly more fine-tuning about how to react and answer the bench. In effect, there are first half and second half, because research and writing are very closely linked, as are oral advocacy and responding to benches. So anything we don't cover today, don't worry, tomorrow will be the remainder. If we cover everything today, even better. At any point, if you have questions, shout out. Just feel free, either if you feel more formally, put your hand up, or just ask away. Much of what I'm going to talk about, you will see on various websites. There are 2 websites that I would highly recommend for anyone and everyone who wants to know about international law and Jessup. There are a few very handy resources provided. One is the Whiting Case Jessup site, and I'm sure everyone knows Google. You can find it. I can provide the link later on if you want. But if you just type in Jessup Whiting Case, it will take you pretty much straight away to the Jessup site of Whiting Case. They have things like this, which is working with the compromis, researching international law. These are snippets of how to do things. Now, much of what I'm going to cover is in these things, but they helpfully have provided a lot more information than you actually need. So the aim is digest it down to what you actually need today, and then you can go back and read whatever else you want to. The second site is the Jessup ILSA moot site, which provides you with a whole bunch of very useful things. The most useful thing of all, if you have the time to read it, is this big piece of information provided. It's called A Guide to see Jessup International Law Moot Court, published by the Chinese Initiative on International Criminal Justice. That's why they've got all these Chinese letterings as you go through it. It's incredibly thorough. It covers everything that you could possibly need. For me, this is the big guide on how to do these things. The rest of it, this stuff is helpful, and it's very short and summary, so you can rely on them. But if you want something more detailed, this is quite a good, handy guide. Now today, in terms of research, there are 3 parts to the entire piece. First is how to read the compromis. Sounds silly, but there are 3 ways of reading the compromis, and we'll come to it. Secondly, it's about being able to research. And thirdly, which kind of mixes with the 2, is actually knowing some basics of international law. Now, I know some of you haven't done international law, so I'll try not to go into too much detail about actual international law. But we might have to at least dip our toes, as the expression goes, into it. Everyone with me so far? Okay, in which case, let's get started. Compromis. Has anyone seen the Jessup compromis before? Has everyone seen the Jessup compromis? It's long, it's complicated, it's 20, 30 pages long, and there is always 4 issues at the end of it. The compromis you will be working on in this school is actually not an international law problem. It's a European Court of Human Rights problem. The first potential issue of what I'm going to tell you, which you're going to see very easily, is some of the stuff I'm going to have to tell you is about European Court, some of it is about international law. Not all of it is irrelevant by any stretch of imagination, because the European Court problem teaches you how to do a number of basic things. But always have it in the back of your mind that the real Jessup, which you're hopefully going to be preparing for, is international law. The big difference, anyone? If you have an individual claiming against the state, it will have to be raised by the state. So a lot of the things you're going to be looking at in this week, you're going to be looking at individual versus state, which doesn't happen in Jessup. However, the ways of researching human rights issues and the ways of researching European Court of Human Rights case law is very useful because, as some of you may know, next year's problem involves human rights and may very well involve the EU. So it becomes quite a useful source of law for Jessup. How to read the compromis. It's 30, 40 pages long. The guys who've done it, how did you start reading the compromis? Start from page 1 and then go to the end? Start somewhere in the middle and...
For the first time, read it twice, understanding what the issues are raised, and then paying attention to the related issues. Like understanding what's the problem and it's like I did.
It's a good way, I agree. Any alternatives?
You could read it like 10 times before you
Probably a little bit of an overkill, we would call. There are 3 main ways that people talk about reading the compromis. The first way, I don't personally agree with it all that much, is what White and Case recommends, which is read it once, end to end. Don't write anything, don't do anything, just read it so you understand it. So you have an idea of what it's trying to get at. Read it a second time and make notes, questions that you have, issues that pop into your mind. And then finally, read it a third time to see if you've missed anything. Now, the difficulty is you're not going to know if you've missed anything unless you know some level of international law. So it falls back to the number 3 point of you won't know it. The slightly better way is what the Chinese talk about, which is read it back to front. You read the prayers for relief first. You want to know what the issues are. So you go to the end, that's the questions being presented. The entire drive of the compromis is, what are the questions? What are you trying to research? What are you trying to get at? Once you have the questions, then you go back to the front and you start reading it. And of course, you usually have to read it more than once. The third way, which actually mixes with either one of these two, is, how many of you have a coach who knows international law, or someone on the team who knows a little bit of international law? No one? I would hope everyone has someone who's helping them who knows some international law. Get them to spend 2-3 hours with you, because you read the compromis and everyone reads their compromis and everyone has their notes. The way I actually do it is, it's probably not ideal. I read it very slowly first time and I write all over my compromis. I highlight underline anything that could be a weird thing. It could be a legal term. If you see something like, I don't know, hot pursuit, or in breach of their right to, and you think, this is a legal term. This must be something that I can possibly pick up. That's usually your starting point. Everything in the margin, some of it is going to be common sense. What are they trying to get at here? Is it about a refugee issue? Is it about a right to water, which is actually this year's problem? Whatever it may be, have it in terms of your own annotations of the compromis. Then sit down with someone who has done international law. As a team, I always used to insist. I am not always present when I am coaching a team, but when I do, first and foremost, the one thing I always insist on is that first week of the competition, ideally, everyone's read the compromis, everyone turns down. You sit down, it takes 3-4 hours. You do a paragraph by paragraph, line by line reading of the compromis. Everyone would have spotted something on each line. The compromis is drafted incredibly carefully. Every word has been mulled over. There's not going to be anything in there which is not supposed to be in there, usually. There will be clarifications because they have missed things. But that very thorough reading of the compromis will enable you to pick up all the issues. And that way you can figure out what is relevant and what is not. And don't forget, not everything is going to be useful. Sometimes, does anyone know the expression red herring?
Yes.
Does everyone know the expression red herring? It's something that they throw in there to just send you down the wrong avenue. There will be red herrings in the compromis. There will be things, suddenly there is a reference to, I don't know, a salvage issue. And you think, how on earth is this relevant? Oh, I know, because there is some archaic 13th century law that could help refugees in case there is a salvage happening at the same time. You will spend hours researching it, and after hours and days, you will figure out this has nothing to do with anything. Sometimes you end up running lines of argument because you think this isn't the compromis, this is really important. I'm going to run a line of argument on the basis of what is here. Not always. Make sure you don't get caught up in the irrelevant issues that they're throwing in the middle of it. So, you've read the compromis, you've sat down, you've digested it. You found out all the relevant issues. There's usually 4 or 5 of you on the team. Am I right? Is any other team here who's not going to have at least 4 people on it? No. If there's 4 of you, fantastic. You've got an easy divide. What you would usually do is, at the start, you have 2 ways of splitting it. Either you split it by issue, one person takes every point, and then researches both sides. Alternatively, you just come up, if you're not sure about how it's going to relate, you come up with the various general points of international law that you need to research. Vienna Convention is a big issue. Someone just does research on the applicability of Vienna Convention on the law of treaties to this year's problem. If there is a specific, very weird convention that none of you have come across, which happens to be in the compromis, someone will take responsibility for researching that specific piece of law and then write a note for everyone else. There are a billion different possible things that you could cover, but so long as everyone is on the same page, then you will be able to have a plan of how to go forward. One thing I forgot to mention, when it comes to reading the compromis, usually it's quite handy to do two things. Draw a map. If you have two states, one is to the east of the other one, there's a minority population on the western border of one country, which is 30% on this side. Draw a little map in the corner for yourself, because it will make it so much easier to understand how the different issues are linking to one another. And secondly, draw a little timeline, because the timing, if they have specific dates given, quite often, 95% of circumstances, those dates are relevant. There is something to do with those dates. So write a little timeline to see how things progress and how things happen. So, you have understood the compromis, you know where you're going, which comes to the next issue. You need to research it, which is going to be most of today's class. You're not going to necessarily be able to research it unless you know what you're researching and how you're researching, which comes into the third point of knowing some degree of international law. Does everyone understand Article 38? Oh, actually no, because some of you haven't done international law, sorry. I'm jumping ahead. So, international law falls into one main point and one main article, which covers everything that is international law. Someone ever asks you what is international law? International law is Article 38(1) of the International Court of Justice's statute. There are 4 categories of international law under Article 38(1). First, treaties. Second, custom. Third, what they call general principles of law. Not international law, general principles of law. Since everyone is writing, I guess I should possibly write some of this down for you so it would be easier to understand what it is that I'm talking about. Don't know if this flipboard is going to work. That's fine. So, you have Article 38(1), which says 4 things. Treaties. Custom is usually a shortened version of customary international law. General principles of law. And finally, it's a lot of things. I usually just call it subsidiary sources. But yes, it usually covers things like judicial decisions. I'm not sure if everyone's going to now be able to read, given how small the print is getting. Highly publicized, highly qualified publicists. Most highly. It's a sliding scale. So this is A, B, C, D. For this week, almost entirely irrelevant because you're talking about ECHR. What is ECHR? Or the convention. What is the European Convention of Human Rights?
Regional treaty.
It's a treaty. So, in the world of international law, you're going to have international law governs interstate behavior. The Council of Europe is a group of states. So, the thing that dictates how they behave with one another is international law, which means that these states sat together and came up with a treaty called the European Convention of Human Rights. So the reason they are bound by it is because of international law. But once you distill it down to you're looking at a treaty, you don't really need to worry about the other things for this week. However, as much as we're going to learn about the European Convention and the European Court a little bit this week, this is the big one when it comes to Jessup. Custom. I'm not going to go into a lot of detail, so bear with me, 5 minutes, and we'll cover the basics of international law. Does anyone know what custom is?
State practice and opinion juris.
That's the two components, state practice, opinio juris. But that's not a definition of custom. Someone give me a definition of custom.
Evidence of general practice accepted as law.
Not bad. Not bad at all. The whole idea is, once something has been done again and again and again, it becomes custom. If states are doing it, it's custom, which brings us to the two component parts. By the way, it has to be consistent, so you can't have too many people not doing it, or too many states. And secondly, it has to be over a period of time. And if there is any bright sparks who want to now be able to turn around and say, but not every time, there is space law. Generally speaking, has to be over a long period of time. State practice, as the name suggests, what states do. Opinio juris. I think it was, I'm going to volunteer you because you were the one who said state practice and opinio juris. What's opinio juris?
It's the legal obligation of the states to fulfill the legal standing of that state.
Almost.
It's a recognition of state practice.
Sorry?
It's a recognition. So when the state practice is recognized,
Almost spot on. It's the belief of the state to be bound by it. So view of the state itself that it is bound by this law. It is doing it because it believes that it has to do it. So that's the generalities of international law. Custom comes in a lot in Jessup because if you have two states who don't have a treaty, there are only two main ways that you can make them do something. One is custom and one is general principles. Given the limitations of what we're doing, I'm not going to go into general principles at this point. If someone wants and is really eager on finding out, and if we have time at the end of the class tomorrow, we'll come back to it. However, for now, you just need to know that much of it will always turn around into there is a treaty between two states. However, one state hasn't, for example, ratified the treaty. Again, I'm very cognizant that we haven't talked about how treaties come into force. So I'm talking about ratification of treaty, where some of you might not know what a ratification of a treaty is. Does everyone understand ratification of treaties? Anyone who doesn't know what ratification is? Oh, come on. I know at least one of you doesn't know what ratification is. Be brave. As it is with always, if in doubt, I'm going to have to explain it. So, a treaty comes into force when two things happen. First, they sign it. Second, they ratify it. Signing means they have an intention to be bound by it. You don't need to write any of this down, by the way, because this is basic international law for the time being, which is not going to come into use this week. This is just to give you a background understanding so that we can talk about the other stuff that is going to be relevant for this week. Once they sign it, It's the intention for a state to be bound. And they are required to, in good faith. I am emphasizing the phrase good faith because for those of you who were listening earlier, I said there are some things that you can figure out that it's a term of law. Good faith is a term of law. So as soon as you saw good faith on a compromis, you should think, good faith, I'm going to circle this one and I'm going to research it. In good faith, put it into law, which is where ratification comes in. Different states have different ways of ratifying. Sometimes it's automatic, sometimes you have to pass a law. I'm not going to go into the intricacies of how something becomes ratified into law. However, once it's ratified, it becomes binding law. If you've signed it, but you haven't ratified it, technically you're not bound by that treaty at that point. So a lot of the times the issue comes into one state has signed it but not ratified it. Or alternatively, one state isn't bound by this very specific human rights treaty. How do you bring it into force? You say, well, this treaty is now custom. There are so many states who do exactly as the treaty has set out, and so many of them are not even party to this treaty, that it is now law. If you do it enough times, it becomes law. That's the whole principle of custom. So, back to the issue at hand. We're talking about research, and the whole idea is that you would be able to pick up these issues. What is the best way of figuring out what is international law and what isn't? Should be a very obvious answer. Read a book. There are a number of general texts. I don't know the ones who have studied international law if everyone or anyone has a favorite textbook. Sounds a bit geeky, but anyone? Preference of textbook for international law? You have named the two most important ones. What's the third one? Crawford is Brownlee. Okay, Oppenheim is the other big one. So what you have is a number of general texts. I wouldn't recommend picking up Oppenheim on day one because you get more footnotes than you get text. But the best book to read as a general starting point, in my opinion, is Shaw. Malcolm Shaw. He has a general book, a general text on international law. It's something like Principles of International Law or International Law or something like that. It's a good book to read. Unfortunately, it is incredibly long. If someone hasn't got the patience, he likes to be very descriptive. So he goes through history and culture and everything. But it's an easy read. You can't spend 15 minutes before bedtime reading Shaw, and it will put you to sleep, but you will also learn something. In my opinion, the most useful book because of how much detail it has is Ian Brownlee's.
It's not Crawford.
I know, I'm about to come to that. He unfortunately passed away quite recently. So now the book is edited by James Crawford. Those are the two books that are ordinarily very useful. I will give you an alternative book which is handy because of different reasons. So these are what you would usually call a general text. There are many others. Akers, someone mentioned, there's Evans, there countless people have written. These are usually the two that people talk about. That's not a general text. That's a cases and materials book. International law is a lot about the case law. Can everyone see that, or is it too tiny at the bottom now? It's a case book. It goes through the various cases that have been set out. It gives a brief summary of what the case is about, and what the issues are, and what the findings of the court were, as well as what the various dissenting opinions may have been. So, strongly recommend that between now and, technically after this week, once you've had some time to yourselves, sit down and read these textbooks. Have a quick flick through it. Have a look at the ILSA website to see what the compromis is about next year, because they give you a little paragraph. It's about right of water and refugees. So effectively, something along the lines of the Syrian refugees coming across into Europe. That's your general idea of next year's compromis. If you read news articles about it, fantastic. You can call it research. You feel good about yourself by the fact that you're reading the news. If you're reading these books, open up to the sections on refugees or right of water, and you will be in a better position. Secondly, other than these textbooks, in order to have an understanding of international law and how a Jessup memorial is supposed to look like, have a look at the past memorials on the Jessup website. Sometimes, one of the nice things you can do is look at the winning memorials. They call it Baxter and something else, Dillard Awards. Look at the past memorials. You will get an idea, and don't be scared if you have never looked at these things before, if you've never done it before. When you see it, it looks very impressive. You can be sure by the end of it, you will produce something which is not too dissimilar. So, as much as it looks fantastic on day one and looks scary, you will get there. Baby steps, as the expression goes. But have a look at those memorials, because it gives you an idea of what it's supposed to look like at the end. And more importantly, sometimes it helps with your research. Why? Should be an obvious answer, again.
Similar issues.
Exactly. Issues keep coming up the same time, same thing again and again and again. It's not going to be identical, but it's going to be a very close comparison of what someone else has spent hours researching and beautifully putting down the footnotes. And again, tomorrow we'll talk about footnoting and how to write these things. But if someone has already spent so much time and effort doing it, there is nothing wrong with taking a shortcut to get there, because there is such a volume of material that you're supposed to cover that with these little shortcuts, you will still need 15 to 20 hours a week to cover everything. So don't be shying away from little shortcuts. Finally, in terms of just moving on from how to do basic research, where I mentioned all of this stuff is located, there is also a handy guide as a basic international law. It's by two people called Robert Beckman and Dagmar Butte. For anyone interested, for a very basic understanding of international law, you have Beckman, it's a nice little digest summary of international law. And you can find it on the, I believe, the ILSA website. Anyone doesn't know, ILSA is the International Law Students Association, which is the people who run Jessup. So, you have looked at basic international law, you've looked at the compromise from past years, and you've done your basic research. Now, compromise is released in September. You've done your reading, you've split the issues, who's doing what. First and foremost, ILSA gives you a basic batch of materials. These are incredibly simple stuff. The general treaties, things like the Vienna Convention on Law of Treaties, almost inevitably will be there. These are not meant to be the exhaustive list of everything you need to know by any stretch of imagination. They are the basic materials. You need to know them and you need to understand why they're there, but don't wholeheartedly rely on them. You need to now start your own research. Any ideas on how to start research? Where is a good starting point? You've all done research. Even if you haven't done mooting, you have done research pieces. Doctrine. Clarify.
Scientific treaties.
It's a good place for research. Not an easy start. You kind of jump into the deep end at that point. No, you start off with the most basic things. You start off with what you read in your textbook, because that will give you an idea. And it will also give you an idea of what is an issue and what isn't an issue. So your textbooks. Every time you read something, textbook is general. The textbook will give you a footnote. Brownlee is excellent at this. If you are following Brownlee's footnotes, or Crawford as it may be now, you are going to find a wealth of specialist knowledge. So, you're reading a specific thing about a very nuanced issue of refugee law or law of conflict, armed conflict, and Brownlee will give you a footnote to another book, which is more specialist in the field. That specialist book will give you articles and will give you cases and will give you everything else you need. It's just a matter of every time you read a text, follow the footnotes. It should be quite obvious for anyone who's done any degree of research that you follow the footnotes. Secondly, and still we're not coming to the doctrine because that's the third thing. Secondly, Google. Sounds stupid, but life has been made much easier with internet search engines. If you come up and do general word searches, admittedly you need to figure out what words you're searching for. You can't just type in the entire prayer for relief and expect Google to magically give you the answer. But once you figure out what the issues are, once you've figured out what the main points are, then a Google search will give you thousands of articles, only a handful of which are useful and relevant. So you need to distill it down to what is essential for your problem. Wikipedia, similar to Google, fantastic resource. If you come up with a case, have a look at the case in Wikipedia. Harris is a good place to look at the case on this specific issue, and it will give you the specific quote and yada, yada, yada. But if you just want to get an understanding of what on earth the case is about, almost every international law case ever heard by any body, ICJ, PCIJ, and a significant number of the important ECHR cases are all on Wikipedia. So you've done your basic research of textbook, you've done your basic Googling. Now comes the hard part. Unfortunately, there is no quick and easy way of doing it. You'll have to go onto the various websites and read the specific journals. That's it. You just have to know where to go. These guides give you a good idea of where to go. Alternatively, the cases you read. If you're reading 6 cases which are all about the European Court of Human Rights, you know the European Court of Human Rights has done a lot of work on this. So you go on the European Court of Human Rights website. If you can see that a journal, let's call it the International Law Quarterly, is doing a lot of pieces on a specific topic, you go on their website and you search their journal. There is a slight shortcut to it. Has anyone come across Westlaw or LexisNexis? It's like Google for lawyers. If I'm not mistaken, anyone who registers for Jessup still gives you access to, I believe, Westlaw, but I'm...
It's all 5. Westlaw, LexisNexis,
Oxford Library.
Oxford Library, and 2 other libraries.
Fantastic. It will take you a little while to figure out, and I was trying to see if we can get some kind of a setup to access Westlaw or LexisNexis to play around with it a little. Once you get access, play around, because you can do searches by key terms. Almost like Google, but slightly less efficient because it's just giving you a lot of legalistic answers. And I say less efficient because everything looks relevant. Whereas with Google, you can quite easily see which ones are not relevant. And you can both pick up various case law as well as whatever articles have been published in the field. And don't forget, it's always easier to read articles than it is to read cases. You should only ever need to read cases. This is the worst possible advice any tutor can give you, but you don't need to read cases. You really don't. If you read an article, someone has effectively summarized that article for you. You only will need, or a textbook, or whatever else it may be. Sometimes you get separate or dissenting opinions, or judgments, separate judgments and dissenting judgments. First one is international law, second one is domestic law. Those opinions and those separate judgments can help you. Yes, the main judgment, 7 of them, 8 of them, 9 of them said this, but 2 of them said something different. And I think these 2 got it right. And then you have to argue around that. So don't jump into a 20, 30 page case which is going to be difficult to read if you can avoid it, because you don't have time to read every case on day 1. Admittedly, later on, this is a 4-month process. Once you've figured out which cases are the most important ones, then you will be sitting down and reading those cases, but not at the start. Any questions or issues? Has everyone understood everything? Yes? Falling asleep? Still here with us? So now we come to treaties. We said ECHR, European Convention of Human Rights, is a treaty. Treaties should have a simple enough definition. Since everyone is awake, someone who hasn't said much. Let's call on someone from the back row. One person, any idea what a treaty might be? Sorry?
It is agreement between the states.
Perfect. An agreement in 2 states.
You can have
Concluded in the written form, but in a single instrument or in 2 or more related instruments and whatever is particular destination.
Wow. That's almost an exact verbatim quote from Shaw. Article 2 VCLT. However, there is one thing everyone got wrong. No, treaties are written. Thank you. It can be a multilateral treaty. A multilateral treaty is not between 2 states. It can be between dozens of states. So, purpose of treaty, to govern interactions between states. Simple as that. You sit down, it's like a contract between states. And everyone has done contract law. Even if you're a first-year student. I don't know, maybe. So, that's a treaty. In international law, we had a reference to VCLT. The second most important interpretive. This is difficult because you have to use a treaty to interpret another treaty. It's an oddity, but that's the only way it can possibly work. The Vienna Convention on the Law of Treaties. I've been talking about it time and time again, but it is the principal instrument, the treaty itself, which governs the mechanism of treaties. It sets out what is a treaty, how it becomes a treaty, the fact that you can't not abide by a treaty, as well as, most importantly for us, interpreting a treaty. However, all of this is about disputes in international law. Why do I say it's the second most important instrument for interpreting a treaty? There are two questions in that. First off, what do I mean by interpreting treaties?
Trying to know the intended meaning of the words or phrases used in the treaty.
Perfect. A treaty has an aim, an objective, which is usually referred to as the aims and objectives of the treaty set out in the preamble. So, a preamble of a treaty is effectively, let's imagine, up here, this is your treaty. You have your preamble here. Preamble doesn't have any binding force. It's not a specific clause. It's like saying, in order to have better friendly relations with one another, because we love each other. That's it. It's trying to get at the aims or objectives of a treaty. Then you have your clauses. Clause 1, Clause 2, which have the binding force. Those are the clauses of the contract, usually referred to as articles rather than clauses, for a reason unknown to me, just to confuse people. That's what you're applying. In order to interpret this, we're not going to punch each other in the face, because we're trying to be friendly with one another. Does that mean I can kick you in the face? Well, no, because the objective says. So even though the specific word might be a punch, the intention was that we're not going to kick each other in the face either. But in order to get to that process, to get to that answer, you need to follow a process. That process is set out in the Vienna Convention, which says, Article 31 and Article 32. What you try to do is you first read the treaty. If it makes sense, perfect. If it doesn't make sense, you have to look at other things. For example, what the preamble says, what the preparatory work says. This treaty, before it got to this, it went through 15 different revisions. Each one of these revisions tells you a story. It says, initially, the discussion was we shouldn't fight at all. But then someone said, well, this is too vague. So it changed, and it changed, and it changed. This is a very difficult piece of research, because you will rarely have someone who's done that specific digest on every issue for you. But sometimes it becomes relevant and important. Treaties are important because it's supposed to give you certainty. It doesn't always give you certainty, so you have to go to a means of interpreting it. It's the second most important piece. What is the most important piece of understanding a treaty? VCLT is the second most important. What's the first? I heard a mumbling somewhere.
Preamble.
No, preamble falls into the whole idea of interpreting a treaty following VCLT. You usually have, with any big important treaty, some kind of guide given to you. So, these guides are often called commentaries. Sometimes they're called guides. These actually set out exactly what is supposed to be in that treaty, what the intention was, what every case law on the treaty is, what every decision on the treaty has said. It makes your life easier. If you're ever having to deal with one of the most important ones, which is on state responsibility, articles on state responsibility, or articles on rights of wrongful acts of states or something like that. I can't remember what ARSO actually stands for. So I've called it ARSO for so long. Thank you. You have the commentaries on each article. And sometimes, if it's a contentious article, it'll go to pages. What we're looking at this week is European Convention. Guess what? Someone sat down and written, article by article, guide of the European Convention. So your starting point should be read the case, read the convention, and then go and read the commentaries written about every article that you're looking at. So everyone remember what articles you're looking at? All good? All make sense? So we're now going to go into a little bit more nuanced detail. Because you're looking at a treaty between states, you need to understand where that fits in with the general scheme of international law and how it could play out. For Jessup purposes, the European Court is one body, which is a very important body for human rights. As a result, you can actually rely on the European Court decisions. It can fall into one of either custom or as a court decision in itself. This is not necessarily about this specific week's problem. This is to know that the work you're doing this week is not going to be wasted effort when it comes to general international law. Because you're going to be looking at human rights, there are a handful of organizations that deal specifically with human rights. One of the most powerful voices is the European Court. So knowing how to research European Court cases, what the issues are, is going to prove very useful for you later down the road when it comes to researching refugee issues or whatever it may be for next year's Jessup compromis. I really am trying to avoid talking any more about general international law. So, one thing I should have mentioned, compromis. We talked about read the compromis, figure out what the issues are, figure out what the law is, and then come back and refine your research. Finally, you go back and you read the compromis again. This cyclical process allows you to pick up things that you didn't pick up the first time around. When you read the compromis initially, you come at it cold. You don't know the area of law. Once you've done quite a bit of research in that area, suddenly things start to make sense. You go back and read it. Words of the compromis have been specifically selected earlier. Why? Because sometimes they are driving at a specific point that you didn't even realize existed. But now, having read some international law, you can go back and read it and pick up on those words. don't forget the most basic things when it comes to doing this kind of research. One, the wording of the compromis is important, not just because it drives at the various points, but also because it allows you to run different arguments for the applicant and the respondent. The prayer for relief for the applicant may be very different than the prayer for relief for the respondent, just by how the words have been put there. If that's the case, that will mean a different line of research for the applicant compared to the respondent. Secondly, the words of the compromis also allow you to run general international law arguments. This is not going to apply to this week because the compromis wording is actually very much driven Article 6 and 8 of the European Convention, but general arguments of international law. You're not going to know these unless you read the text, as in a generalist text of international law, or unless you've done a course, or hopefully if you have someone in the room with you when you're doing that reading who knows general international law. Things like clean hands doctrine. Unless you've done some international law, you're not going to know what clean hands is. And you're not going to come across it specifically when you're researching a point of refugee law. But something like clean hands is always important. General points like jurisdiction and standing. These are things that ought to be obvious to someone when you are sitting down with your team. If it is not, get one of your people to research jurisdiction. Does everyone know what jurisdiction actually is? The ability for a court to hear a case. What's the difference between jurisdiction and standing? Slightly trickier question. Thank you. The ability of the people who are bringing it to bring it. So the court can hear it, but that person may not be able to bring it. These things are basic, but they will always play a part. I don't know how much time I have left. Another hour? Perfect. In which case, we can now talk in a little bit more detail about Jessup. So, Jessup compromis has 4 issues. Every year, it's the same. I don't know if, do you guys have a practice of taking a little break between a 2-hour class or not? You do? No, maybe, yes. I'm comfortable carrying on for another 2 hours if needed. But if you guys are going to switch off after an hour, I'd rather actually have your attention for the full 2 hours rather than and take a 5-10 minute breather rather than just persist. Okay, fine. Show of hands. Who thinks they absolutely should have a break and it's a breach of their human rights if they don't take a break? Not a single person. Who absolutely insists that there should never be a break? 1 person, or 2 people. So we have a majority of 2 out of a class of almost 30. Take 2 minutes to 5 minutes, 5-minute break, and then we'll come back to it. So, now that we've had a little break, a couple of points. First of all, I mentioned jurisdiction, standing as the key basic points of international law that you should always bear in mind. I mentioned something like clean hands doctrine as another basic point that you should always have in the back of your mind, but I didn't actually tell you what clean hands doctrine is. Clean hands doctrine means something along the lines of, you cannot appear before the court with unclean hands. That is to say, you cannot say someone else has breached the law where I myself have breached the same law. So, if I have started killing people indiscriminately on the basis of, I don't know, their race, I can't then turn around and say, but you're killing my people based on their race. Well, you're doing the same thing. it prevents you from having a legitimate basis for raising the argument because you are just as guilty. There are other general principles that you need to always be aware of. One of the most favorite ones is burden of proof. Burden of proof is a complicated issue, but it boils down to he who asserts must prove. If you're raising an allegation, you must prove it. In Jessup, it is usually a detailed compromis which is supposed to leave you little scope for burden of proof arguments. However, they are usually still there because the facts can never be conclusive with even a 20-30 page document. With an ECHR case, where you have a 4 or 5 page fact set, burden of proof can be a fantastic tool. If in doubt, try to formulate it in such a way that it is effectively the other side who is arguing and trying to prove something. And then turn around and say they're trying to prove X, but they haven't demonstrated the facts to prove X. Therefore, they haven't satisfied the burden of proof. It is fantastic because it's so simple. And you will have all these cases about who has the burden of proof. On burden of proof, I will briefly mention one proviso, which is that sometimes you do have what they call a reverse burden of proof. The only reason I'm mentioning it is because it falls into the sphere of, as you've guessed it, human rights, and in fact ECHR. For some human rights issues, it doesn't matter the fact that you are trying to prove something and the facts are not there. Sometimes the other side has to disprove you. Happens because of, and I don't know if anyone, has everyone read this Summer School's compromis? Good. Did anyone pick up on the fact of a little phrase called equality of arms? Thank you. As you were reading it, and I said, when you're reading a compromis, what you try to do is try to pick out anything which is a potential legal term, a term of art. Equality of arms is one of those fantastic terms of art. If you have some background of how to read these things, you would have automatically, even if you don't know what equality of arms is referring to, you would have realized that this is not a normal phrase to say, equality of arms. What on earth does that mean? It's actually a French principle, which means the state has a lot more power. As a result, the state is unequal in terms of arms. It's something along the lines of they're bringing guns and all I've got is knives. The other side has much bigger arms. Not arms, but weapons. So the state has a higher onus usually when it comes to individual versus state. Applied in specific terms to torture cases where someone is tortured, held in prison without any kind of trial rights. Again, fair trial rights. It should clue you in that these are the buzz phrases that will happen again and again and again. So, how can you prove that the state held you in a detention center without any due process in secret, in a facility that doesn't officially exist? How can you possibly prove that? I'm hoping the blank faces because you're trying to say you can't.
Whistleblower.
Well, you can't. Someone else is potentially going to whistleblow on you, on the whole institution, but you can't. So what ECHR effectively said is, if you are in the vicinity and you can provide some basic information, and the example is something along the lines of the person is found kind of looking beaten up in the area that he's claiming to have been held. In that case, it is for the state to disprove that they held you in this secret detention center. That is the minor exception when it comes to burden of proof, but unfortunately it's an exception that is grossly misused and overused when it comes to Jessup. Because what in Jessup you always try to do is try to formulate something which is certainly not set law as this is the law. Well, no, it might become the law in 20 years' time, but it isn't quite yet the law. However, you always stretch the limits of law when it comes to these things, and burden of proof is a perfect example where people start to stretch in terms of where a burden of proof can be reversed and cannot be. And one minor point, which goes back to the start, that you have to always bear in mind the jurisdiction of the court. What does it have competence to deal with? If you're asking a court, the ICJ, to rule on domestic law, good luck. It's not supposed to, and it is not going to do it. ICJ will only look at these things. So if you turn around and say, this specific Ukrainian law is discriminating against me, no, it's a domestic law. ECHR is a little bit different, because ECHR can look at where a domestic law is breaching an individual's rights. So always have in the back of your mind, can the court even look at this thing? Equally, if you decide to take something which has nothing to do with ECHR to the ECHR, they're going to say this is not our remit. We cannot look at this. So have all of these little things in the back of your mind as you're formulating your arguments. Now, has anyone previously looked at any actual cases end to end? Not one person is. Oh, you have. Good. Which case?
Kyiv and Duff versus Italy. And,
You're talking about ECHR cases, right?
Yeah.
Sorry, my mistake. I haven't looked at either one of those cases because ECHR is not my subject matter expertise. You'd be glad to know, in part because well, UK may not be part of ECHR for very long. Who knows? But ECHR cases are actually easier to read than ICJ cases. They are much shorter. But when it comes to any case, and I don't know if Ukrainian case law is the same, I don't know if you guys actually read Ukrainian case law. Of course, as a civil jurisdiction, you don't care about it, even though it's supposed to still help interpret the law. In common law jurisdiction, everyone knows the distinction between civil law and common law. Yes? Perfect. Because in common law countries, for me it's instinctive. You always look at the case law because it is precedent setting. In international law, it is not precedent setting, but it is still interpretive. If the court has said something, they are not easily going to change their mind on it, which is why citing case law is always important. So you have your rule, and in order to establish the rule, you refer to the cases. In order to read a case, you start from the beginning, as obvious as it might be. Who are the parties? It will say it right at the start of the case. What the facts say, what the fact and circumstances are. And then you will have this entire detailed assessment. If it becomes confusing, flip to the end, see who won. Because quite often they will go through examining each point and then get to the end saying, in conclusion, the applicants win or the respondents win, depending on the court that you're looking at. But they will always follow a very specific formula, which is parties, facts, analysis, conclusion. This is also going to be very similar to what we talk about in terms of writing tomorrow, because it makes sense. Now, the fact set sometimes is split. So if you have a number of different issues and facts which are applied differently to the issues, they quite often split the facts into an issue-based facts. The facts on this point are these things. Sometimes they split it depending on what the parties have said to be the facts. This side has said this is the fact set. The other side has disagreed, saying this is the fact set. This is also quite common, again, when it comes to compromise. I'm hoping everyone is now realizing that from the starting point of there are three distinct issues, now everything becomes a little bit more mixed. So you flip back and forth between the fact that you're reading a compromis, trying to digest it, trying to understand what the basis of the law is, and you are trying to apply it effectively to that. But when it comes to the facts, different sides have different ideas of what the facts are. So when it comes to reading any compromis, pay specific attention as to whether something happened or whether someone said something happened. Compromis is an agreed set of facts. If it says that Mr. X and Mrs. Y had a fight, and Mrs. X slapped Mr. Y, and Mr. Y threw an apple at Mrs. X, that's a fact set. If it says Mr. X and Mrs. Y had a fight, Mrs. X says Mr. Y threw an apple, that is no longer a fact set. That is a statement of Mrs. Y about what happened. It is a key distinction because you cannot rely on that as something that actually happened. If you're representing Mrs. X, it is your client's statement. If you're representing Mr. Y, it's nonsense. It never happened, unless he agreed to it. Clearly, in the compromis, the agreed facts, he didn't agree to it, therefore, it's just her statement. We talked about this seconds ago. What happens next? What is the most important thing of why you need to be able to distinguish what is a fact and what is a statement? Thank you. She now has the burden to prove that he threw an apple at her. If she cannot do that, Mr. Y will say she didn't satisfy the burden, and therefore it didn't happen. So always be mindful of these little things. Now back to it. Cases. Cases are important, as I was saying earlier, because they actually either set a precedent or alternatively they inform the court's view. You need to be able to read these cases. When it comes to this week, you will need to read a few of these cases, unfortunately. But if you recall, I said don't ever start with a case. You should only read cases if it becomes necessary and useful. Your starting point should be the almost. You've already gone beyond the textbook at this point, I would hope. And you are on a compromis which is specifically telling you research Article 6 of ECHR and research Article 8 of ECHR. Thank you. Does anyone know if there are commentaries for Article 6 and Article 8? Perfect. You have the guide and you have the handbook. Those things will actually tell you vast majority of things you need to know. Open them, have a read of them. You've already read the compromis. Does that mean you just write it down and end of story? What's Article 6 about? What does that mean? It's huge. What about Article 8? Family life. What is family life? Sorry, private life. Private life. Again, it's huge. There are things that you don't automatically assume to fall within the scope of these articles, which actually do. So once you read the commentaries, the guides, the handbook, you will then figure out that there are all these other lines of argument that you may have missed. So you go back and you read the compromis again. Compromis, commentaries. Back again to the compromis. At this point, you should have a fairly good idea of what it is you're actually going to be looking at. Given that time is limited, you should ideally, and especially since with ECHR, those commentaries are so thorough and detailed, you don't really need to look elsewhere. I know I'm possibly going to make you a little bit lazy by telling you exactly what you don't need to concentrate on reading other than that. But for this week, that's all you will probably need to do. Read the commentaries. However, there may be instances where some of the cases that you're talking about are going to be very, very pertinent and useful. In which case you go and you research the case. Where can you find ECHR cases?
Why it is called hudok? I always was interested.
Sorry?
Why it is called hudok?
I have no idea.
I was trying.
I have no idea. It's always been hudok. Something about human universe, decisions of... in case you didn't catch that, and you were not aware of it, it's HUDOC. There is an easier way if you cannot remember that. You Google ECHR decisions. The first link, I think, yeah, I'm pretty sure it's the first link, will be a link to hudok. If you know the case, fantastic. If you don't, you can actually search by subject matter as well. Admittedly, again, given that you have very limited time this week, you might not want to do too much random research on hudok because it's huge. It's the entire database of every ECHR case for the past 70 odd years. So instead of just randomly and blindly searching, go from the commentaries, figure out which cases you have to read, and then only read those cases. Fortunately for you, ECHR cases are short, so you don't actually have to spend a hell of a long time reading them. Jessup is different. When it comes to Jessup, after you read the compromis, having already read some kind of a basic text, you then have to come back and start your research. Of course, because you have so many different issues, it would have to be split into different points and different people researching those different points. My strong recommendation is that you would split it by issue, because where you have, in this case, split into Article 6 and Article 8, if there's two of you, guess what? One of you is going to probably be looking at Article 6, one of you is probably going to be looking at Article 8. When it comes to Jessup, there are 4 issues, and there's 2 of you. How do you split that? Does everyone understand when I say you have 2 people, not 4 people? You have 2 people as applicant, 2 people as respondent. Only 2 people will ever speak. Where you have 4 issues, when it comes to research, it's easier. That one person will pick up issue A, research both sides. One person issue B, research both sides. But when it comes to the actual final split of how you're going to be doing it as applicants, one applicant will have to pick 2 issues and one applicant will have to pick 2 issues. Same with the respondents. How do you split that? Come on, it's got to be obvious.
Maybe on the basis of some personal interest in some particular issues?
Or the most similar cases?
Well, your starting point is usually who likes what, but more importantly, issues 1 and 2 go to one person, issues 3 and 4 go to the next person. However, not always. Sometimes 2 of the issues are very closely linked. If you have, I don't know, this year's problem, right of waterways, refugees, general human rights, and then, I don't know, toxins. Now you will automatically see that 2 of the issues of refugees and human rights are going to be closely linked. So someone will do issue 1 and 4, someone will do issues 2 and 3. Don't be too eager to have that done, but don't forget that after your basic initial stab at research happens, if you are doing it, each person doing 2 sides, at some point you have to switch that. So that one person is looking at 2 things and their counterpart is looking at 2 other things. The best way to do it when it comes to Jessup is you start off 4 people, each looking at 1 issue, both sides. Depending on who and how you guys will split it, if you are doing 1 and 2 and 3 and 4, little by little, the 2 people who are looking at 1 and 2 on both sides should come together and talk to each other and research together, because they will be researching stuff that the other person is going to use, and vice versa. Does that make sense? Perfect. And at some point, I don't have a strong preference personally one way or another, whether it's before memorials are done or after memorials are done. You will split it into how you would be pleading it. There is an alternative way that I mentioned earlier, that you just initially research topics. At some point you have to move away from topics and concentrate on the 4 prayers for relief. But there is also a third way. You can just split it from day 1. I am responsible for applicant 1 and 2. You're responsible for applicant 3 and 4. This one is responsible for respondent 1 and 2, and the final person respondent 3 and 4. There are advantages to that, because from day 1, you get into the mindset of what you will be ultimately doing and what you will be ultimately pleading. So long as you don't get caught up into, this is it, this is my little corner, I'm not going to touch anything else, it can have its benefits. But again, doesn't matter how you do it, that you will have to talk to the person opposite you, because where you're researching 1 and 2, they are researching 1 and 2 on the exact opposite side. Everything you read, they should be reading. It would be wasted effort if you're both reading the same thing twice. So what you can do is, you split the workload. You read some stuff, you do a little guide for them, even if they're going to go back and they're going to say, well, I still like to read everything for myself, they at least have a starting point of the key issues that you've picked out, the key bit that you've dismissed as invalid lines of argument. The second advantage of doing it this way is you also have a co-agent. So if you're doing 1 and 2 and someone is doing 3 and 4, you would be co-agents. Why do you need to talk to your co-agent? Someone has to answer this question, otherwise we're going to be here all day.
We will have rebuttal and rebuttal, and we should know at least some minimum for what about your co-agent will be.
Correct, but that's secondary. There's something before that.
Judge would ask something from their part.
Similar point, secondary. You always need to know a little bit in case the judge asks, in case you need to do rebuttal. Before all of that, why is it so very important to know what your co-agent's going to say? Thank you. Contradictions. If you stand up and say something about how refugees are evil scum and they should all be killed, and it just so happens that your co-agent is arguing on behalf of these refugees, that's it, you've lost. You cannot possibly contradict your co-agent. It's never going to be that black and white. It's going to be slightly more subtle. And Jessup has a habit of trying to force you to contradict one another. The downside is not for you, it's for your co-agent who's going to stand up after you. He's going to stand up and say something and the judge will say, but your co-agent just told us the exact opposite. And then he will have to sweat for 5 minutes because the judge is not going to let him walk away from it. He will either have to say, I'm wrong, my co-agent is wrong, or we're both so very sorry, we'll just go commit suicide right now. To avoid that, you need to make sure you have a consistent line of argument with your co-agent. Otherwise, good luck. That's all I can possibly say. Secondary reason I heard from 2 different people, the judges don't discriminate between whether it's your issue or whether it's their issue. They will ask you the question. We'll come on to how to answer these things later on. But for the time being, just bear in mind that you will have to have at least an understanding of your co-agent's arguments. It's not the most pertinent thing for research purposes, but it will be for responding. And of course, when it comes to rebuttal and surrebuttal, I don't know if everyone understands or has come across the term rebuttal and surrebuttal before. We'll come on to it later. Don't worry. It will be covered at some point. For the time being, on this. All good? Finally, arguments are good. Not every argument is good. Be mindful of the impact of your arguments. This is far more about research than it is about anything else of writing, oral advocacy, or anything else. Don't make ridiculous arguments. Yes, you research. Yes, you cover the most weird and wonderful things. Not all of it is going to be useful. You just have to accept that of the entire hours of research you're going to do, only maybe 50% of it is going to be useful. And no one's going to have sympathy for you saying, but I spent time researching this very weird point, so I'm going to argue it. No, there are such things as bad lines of arguments. Whether it is because of a red herring that you're going down the entirely wrong line, or whether it is because you're just missing a key component, or if it is just because you're throwing it in there since you've done the work on it, why not? Making a bad argument is better than not making an argument. Sorry, it's worse than not making an argument. Pick your arguments carefully. You don't want to be making too many. You don't want to be making too few. As Goldilocks will just say, it's just the perfect amount that you need to pitch at. So find everything and then talk to each other. Is this relevant? Is this going to help me? Is this going to contradict you? And this will apply to ECHR as much as it will apply to Jessup. You will have a lot of lines of argument that will come up. You don't need to make every single one of them. The fact set is there to have a lot of potential nuances, so you can have different lines of argument. As much as this is more about pleading than it is about research, you should always try to apply the rule of 3. You have 3 points to make. You always have 3 points to make. Preferably, you can potentially go to 2, or you can go to 4. But ideally, you will have 3. You don't need to necessarily only argue the stuff you've written down, but for the duration of this week, I want you to try to only argue what you have written. If something fantastic comes up later on and you have to argue it, fine, do that. But given how short this duration of this research piece is, concentrate on making the most important arguments as your research points. If you have additional things, don't worry too much about it. Just put it down as to a line of argument that you have considered and dismissed. Any questions on how to dismiss arguments or whether to dismiss arguments? I know it's going to be painful. You will constantly want to say, but I've done so much work on it, I want to put it in. No, it's not going to help you, so why put it in? Make sense? I did say finally, but there is one other thing. When it comes to research, I keep saying compromis, research, back to compromis, research. Having bad arguments in terms of arguments that you shouldn't make is far from ideal. What's worse than that is having bad law. Misunderstanding the point of law, terrible thing. What is the one thing which is worse than misunderstanding the law?
Not knowing the law.
That's just as bad as getting the law wrong. Not knowing it and getting it wrong. Same thing for me.
Interpretation of law.
Nope, you're still concentrating on the law side. There's the other side. The little circle that keep going back. Thank you. And it's actually going to be, for research purposes, less to do with knowing the facts and more about understanding the facts. Getting the facts wrong. It's a natural human instinct to frame things in the way that it would suit you. Don't do it. If you lie about the facts, if you misrepresent the facts, if you misunderstand the facts, there is no excuse. It just looks bad. It looks like you haven't done the most basic piece of work in order to get to the conclusion. So, whilst someone can read a 20-page case law and misunderstand it, no one can misunderstand a paragraph of the facts, which you are supposed to have read time and time again. Do not ever get the facts wrong. I can tell you from personal experience, in a round that we had, one of my co-agents got the fact wrong. We lost the round immediately. And he got it wrong in the rebuttal. We'd won the round, it was done and dusted. He said something stupid in the rebuttal. And we all just went, before he even sat down, the three judges just went to the back to the clarifications that he pointed to, read it, and just went, that was it. Don't ever get the facts wrong. Getting the facts wrong in a mood, pressure, yada, 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 maybe. Not in the research piece. You cannot possibly misunderstand the facts. Crystal clear? We don't need to cover this stuff today. We'll come back to it tomorrow. There is one thing, sorry. Finally. When it comes to research, have it always in your mind how you're going to structure it. Your strongest argument comes first, then your kind of backup argument, and then your backup argument. A good team will have a good backup argument, but it's not supposed to be something that is readily defensible. When the judge asks you a question about it, or when someone grills you about it, you can just say, come on, it's my backup argument. Realistically, I'm not going to know much about it. It's not going to be a good line of argument. It's just there. But you will always lead with your strongest argument, because that makes the most sense. And as lawyers, you're all trying to apply common sense first and foremost. I've overrun, I know already, but just by 2 minutes, so it's fine. Any questions? Enjoy and good luck.